Thank you very much. I appreciate it. Thank you. Thank you for inviting me out today. And again, my name is Doug Kotarek of the law firm Hall & Evans. And gosh, to avoid the heat, I guess I've been going swimming a lot, trying to do that. But I would like to remind everybody, we recently were in Florida visiting some relatives there, and the temperature there is about the same, but the humidity is just incredible, and so you almost like hit a brick wall every time you come out the door. So we're lucky to be able to live here in Colorado, and you go outside on your patio in the evening, and it's cool, and it's a lot nicer. And also, don't forget, I know that come January, if we're here in this meeting again, everybody's going to be complaining about the snow on their driveway and how freezing it is. So let's remember that maybe it's not as bad as we all think it is. But anyway, thank you very much for inviting me here. I love coming down to Boulder. I grew up in Broomfield, and I've been in Colorado pretty much all my life. And I remember as a kid riding my bike down to Boulder. Can you imagine that? I'm like 13 years old, riding my bike from Broomfield to Boulder and back in a day in the summer. It would never happen nowadays, but I remember doing that. But anyway, Boulder's a pretty city, and I always love coming here. But by way of introduction again, I'm with the law firm Hall & Evans. Many of you I do know, and I'm very involved in the Self-Insurers Association, and so I know you from there. But for those of you that I have not had the chance to meet, I am the head of the Workers' Compensation Department at Hall & Evans. I've been doing that. I've been practicing for 34 years. I've been at Hall & Evans for 20. We are a full-service insurance defense firm. We've been around since 1932, and some of you may do work with our law firm and other areas because we do have a public entity department, and we do a lot of representation of public entities, not only in workers' comp, but in general liability, employment, a lot of different areas. So again, thank you for inviting me here today. I'm going to be talking about the legislative changes that have occurred this year. I am part of a group that actually meets every year with the Claimants Bar, the WCEA, and also with Pinnacle Assurance. I represent the Self-Insurers Association, and we get together every year to talk about legislation. There's probably a group of 10 to 12 of us that do that. And the purpose is to try and reach some type of consensus in order to change for the better, hopefully, the workers' compensation laws in Colorado. I've been doing that for probably 20 years or more. So a long time, have a long history. As you can well imagine, those conversations change every year, frankly, depending on who has the leverage in the legislature, whether it be the WCEA or whether it be the business CSIA, Pinnacle Assurance. For the last probably 6 to 8 years, the leverage is with the WCEA. And the reason that is because typically the Claimants Bar or labor is associated with the Democratic Party because they're more pro-labor. The Republican Party is more pro-business. And in Colorado, we've gone from a pretty solid red state, Republican state, to kind of a purple state, a mix, to now, over the last 5, 6 or so years, it's a solidly Democrat-controlled state. So we have a Democrat governor, a Democrat state house, and a Democrat state senate. What that means is that if the business community wants to run legislation on workers' compensation, we don't have enough votes down at the legislature. If the Claimants Bar wants to run legislation, they do have enough votes. What keeps everything in check is the thinking that nobody wants to change things too much to adversely affect the economy in Colorado. But what you will see is that there consistently, over the last several years, there consistently is legislation passed that is pro-claimant. And so you may say, well, you may have asked in the past, well, why is everything in favor of the claimant? Let's go out and do something for employers, for municipalities, for whatever. The honest truth is, we just don't have the votes. And so our job in these meetings that we have every year is really to try and mitigate and to try and not allow too drastic a change to happen that can adversely affect the bottom line. Now, for public entities, your bottom line is taxpayer. I mean, your bottom line is funded by taxpayers. And so when we talk about that, when we go down to the legislature, that actually carries a lot of weight. Legislators don't like to have it said that this is going to increase the burden on taxpayers. And so that they are very sensitive to that. So your help as an organization, or perhaps individually as a municipality or a county or what say you, your help is very essential. And I'll explain that in a little bit as to how it has been these last couple years. So, with that introduction, so what I want to talk about is what was passed in 2022 and what could have been passed over the last couple of years. 2020, March, we're in the midst of the legislative session. The legislative session runs from January to May. Here comes March 2020, COVID hits. What happens? Everything shut down, including the legislature. So in that, and then when they finally started attending again virtually, which was later in the year, they extended the session. Frankly, all that they were worried about was trying to deal with issues to address COVID. Well, one of those issues in 2020 was to try and pass a bill to create a presumption of compensability of COVID cases. And that was a movement that was going across the whole country, where everybody was, rightly so, they were very appreciative of healthcare workers, of emergency responders, of everybody on the front line dealing with this, especially when we didn't know really what was happening. And this was before a vaccine, and everybody was very appreciative of that. There was a very large push everywhere, including Colorado, to try and create a presumption that if somebody got COVID and they were in an essential employment, that it would be presumed they got COVID on the job and they would be provided workers' comp benefits. Well, in Colorado, in my opinion, I think the WCEA tried to grab a little too much. And what I mean by that is their definition of who was an essential worker was huge. It almost involved everybody. So it would be very rare if anybody would be excluded from that group of excluded workers that would benefit from this bill. Additionally, they tried to say that they created this presumption, which means that if somebody got COVID, it would be presumed they got it on the job. They wanted to say that the only way that could be overcome was to show by clear and convincing evidence that they didn't get COVID that way. That's almost an impossible standard to be able to show. And so in essence, everybody, there would be a large group that would be deemed to have got COVID on the job, and we really wouldn't have any way of defending against that. If you remember back in the summer of 2020, there was everybody was being shut down. Tax revenues to municipalities were being stopped. We were doing these COVID relief bills. It was truly unknown what the effect would be. Additionally, when we started pricing what this legislation would be, especially for public entities, the cost was thought to be enormous based on the thinking at the time. And with the help of public entities, we went down, or I should say we testified virtually, and we were able to beat and defeat this bill, even though there was a lot of support behind it. So there was no presumption of COVID passed in Colorado. Any COVID claim is dealt with just like any other workers' compensation claim. The claimant has to prove that they were in the course and scope of employment, that it arose out of their employment, that they got it on the job. They have that burden. As you know, this is a communicable disease. You can get it anywhere. So the impact in Colorado has not been as significant as perhaps in other states. So that happened in 2020. 2021, we're still in the midst of COVID. There is a huge push nationally to try and give claimants the choice of physician in their workers' compensation care. And you can hear it now. Why can't I go to my regular doctor? I feel comfortable with that doctor. I trust that doctor. That doctor knows me. I want to be able to go to my regular doctor if I get hurt. Well, the problem with that are many. For example, our workers' compensation law in Colorado is one of the foundational things that the law is built on is the right of the employer to be able to choose who provides the medical care. We have the third edition of the AMA guides. The doctors have to be trained in order to give impairment ratings. They have to know the medical treatment guidelines, the causal relationship of the activities of a job and the injury. There's a lot of things that go into dealing with workers' compensation law. But having a claimant be able to choose their own physician kind of sounds good. Again, it had a lot of public support. 2021, here we are again, a battle. Again, this was a time when really no legislation was being passed except if it dealt with COVID. This was a little different. We were able to garner up a lot of business opposition to try and beat this. What ultimately beat it, though, was that the director of the Division of Workers' Compensation wrote a letter to the legislature, which I can't, in my however many years that I've been doing this, I can't remember him ever doing it before, in essence, coming out in opposition, saying, listen, there's too much that goes into this, not enough studies been made, this will drastically change the workers' compensation law, we don't think that it's appropriate. That killed it. And we dodged a bullet there, because as you can well imagine, if a claimant ever gets the choice to choose a physician, I believe that will drastically increase the cost of claims, not only the cost of the medical care, but I believe that would also drastically increase the cost of indemnity benefits, both in keeping workers off work a lot longer than they do now, and I believe also resulting in higher impairment ratings and have higher permanency awards. So we were able to avoid a bullet there also. Now, these two bills were not part of that negotiation. During COVID, those negotiations kind of were put on pause. These bills were brought up independent outside of that group. And that was the first time in a long time, that we have seen the WCEA try to push legislation without going through that negotiation group, which frankly kind of upset us, because we've been kind of working under a professional agreement that we would address everything in this group and not go outside of it and try to do an end run. But we really don't have a lot of say in it because, again, we don't have the votes. If they want to do something, they can. But in these two instances, we were able to defeat it. This last year, the WCEA tried to, again, under the same thing of a claimant choosing your own doctor, they said, well, listen, if you have a division IME, and that division IME disagrees with the authorized treating physician and says the claimant is not at MMI, the claimant bar was saying, well, it's ludicrous to send the claimant back to the authorized doctor who said the claimant was at MMI and tell that doctor to do more treatment and put him at MMI again. Well, that again kind of has a ring of common sense about it, but because the effects of it, and when you drill down into the details, it affects so many things and there's so many unanswered questions. Again, that bill was kind of taken off the table. The reason that I'm telling you this is that rest assured, these themes will be coming up in years coming next year, the year after, choice of physician, things like that. Again, I don't believe that the election this November will really change the making or how the legislature is configured now. So I think the majorities as they stand now will continue, and so we'll be continuing to play defense, trying to mitigate these damages. So, all right, I've been talking about what didn't pass. Now let's talk about what did pass. This last year, there were actually 3 bills that passed. 2 of them did not come through that negotiation group. One of those is this House Bill 1112. This was the one that talks about when a claimant provides notice to the employer of their injury. If you all look in your lunchrooms, you have that little placard that said, a claimant has to provide notice within 4 days, and it's got to be written notice. Well, the claimant's bar came to us and said, listen, this is very confusing. That notice seems to indicate that a claimant only has 4 days to report the injury, and if they don't do it within that 4 days, then they can't bring a claim. We all know that's not the case, but I would have to agree that that placard is very confusing. So initially they said, well, we just want to kind of make the language less confusing. Well, as you can well imagine, that from that initial request, it morphed into more things as time went along. What the bill now says is that an employee must notify the employer within 10 days. It used to be 4. Additionally, it says it can be in writing, or if the employer knows of the injury, the employer is supposed to submit the notice. Well, we do have an affirmative obligation. If we, the employers, know of an injury, we have to fill out a first report of injury. So we do have that affirmative obligation already. So this really isn't that big of a requirement. But what it does say is that we, the employer, must make available a copy of that first report of injury to the injured worker within 7 days of when they request it. So let's say somebody files a claim. You know that typical packet that you send out to the claimant that says, hey, welcome, or whatever it is, and you send the claimant Bill of Rights, the claimant's rights, and you send them the packet of who the adjuster is and this and that. Well, what we suggest is that you also send in that a copy of the notice of injury that you all have received. so that you can comply with this requirement. Now, one of the things that the claimant bar also wanted to do is they said, listen, we want to do away with that penalty that if somebody doesn't report the injury, that they can be penalized 1 day's compensation for every day they do not report. Let me give you an example. Let's say that you have somebody that works for you and they quit or they're fired on February 1st. And you don't hear anything from them until May 1st when they say, oh, by the way, I got injured, January 31st, the day before I was fired. And I haven't been able to work for the last 3 months and I'm filing a claim. Well, what you can do, because no notice was provided, we say, well, great, you can still file a claim, but you are going to be penalized for those 3 months. You can't request lost wage benefits for those 3 months that the employer knew nothing about. They wanted to do away with that penalty. We were able to keep it in, and we were able to maintain that defense. It's not used very often, but I think it's an important defense to motivate people to actually notify the employer of the injury, as opposed to waiting for months, claiming a lot of lost wages, and then notifying the employer much later when, frankly, you can't really investigate the claim any further. Maybe people have quit the job or moved on or whatever it is. So it just provides motivation to people to report the injury. Now, additionally, what the statute says is that the employer, if we do not provide that written notice of injury to the claimant, that the statute for that penalty to the claimant is told. So, for example, if we don't provide that written notice to the claimant, then we can't assert the defense that they didn't provide us notice of the injury. Well, that just doesn't make sense. If we have received notice and failed to provide that written notice to the claimant, we already know of the injury. So the penalty for not notifying the employer really doesn't make sense. So we said, fine, if you want to put that in there, that's fine. It really has no effect on us. If we have written notice of the injury, we are going to know about it, and therefore we can investigate it, and we can move on from there. So, the other thing is this. With occupational disease cases are different than acute injuries. There's no specific time when it starts. So what this also says is that notice must be given within 30 days of contraction. When do you contract an occupational disease? When does it become a valid claim? An occupational disease claim becomes valid when it becomes disabling. So you might have somebody that has painful wrists or elbows, and they might have epicondylitis of their elbows, but let's say they're still doing their job. Well, it's not disabling yet. So even though they have pain, it's not a reportable injury. They can even go to the doctor for treatment. Let's say the doctor says, well, I'm going to give you some medication or physical therapy or something like that, but you can still do your job. Again, it's not disabling you. But if the doctor says, listen, I want you to cut back, only work 5 hours a day, or don't lift more than 25 pounds, now it's become disabling. And so that is when we have to, that is when that 30-day notification period starts for the claimant. Also, there was an agreement to change the wording on that placard. There's actually going to be a hearing at the Division of Workers' Compensation. I believe it's sometime in August, where they're going to be talking about that language change. I just saw a notice come out. Frankly, I can't remember the day, but it's going to be, excuse me, it's going to be something that clarifies what the law is with regard to the notice. So this bill will take effect in early September. It takes effect 90 days after the termination or when the legislature ended. So this notice requirement will be coming into effect soon. That's this first one. Does anybody have any questions on this one? All right. Yes?
Doesn't the 10 days open you up for more potential questions regarding where the injury may have occurred?
Absolutely. And I think what the claimant bar wanted to do is just allow more time for a claimant to have to report the injury, because a lot of times, as I'm sure you know, a claimant will say, well, I hurt my back yesterday, but I thought it would go away. And it never did go away. But you're right, that 10 days will open it up. And so that's why when we get claims, we're going to have to investigate them a little more thoroughly. You know, if they say, yeah, 10 days ago, this happened. But a week ago, the person rode in a rodeo and they were, doing something. So there might be other things that have caused that injury to occur, and we'll need to investigate. Paula.
Sorry, just to clarify the notice poster, it is an August 10th date that employers need to have the new poster posted in their location.
When does that hearing, when's the hearing?
The division did a webinar on July 7th, something like that. I can send you the information.
I thought there was another hearing coming up on that.
Well, I think on Rule 3 there is, but the poster notice, they have made it clear it needs to be posted at all employer locations by August 10th.
And
they changed the size, it's like 27 by 40.
yeah,
And
it's huge now.
It's not flexible, you have to, that's the size it has to be, and yeah.
Well, I appreciate that clarification. Where can somebody get that poster?
The division has a link of what the poster looks like and the coloring and the wording and everything, but
You've got to print it out yourself?
Yeah, find a printer that'll do it. The division was going to start doing it for $10, but they're not able to quite get that done in time.
Thank you. Wendy?
I was going to say the same thing.
Oh.
I sat through that webinar.
Yeah.
Yeah. So.
We ordered some posters through Employers Council, if that's helpful to anyone.
And they have them available or something like that, I assume?
My understanding, yep. And then
Fingers crossed.
CIRSA is also sending us some posters as well, so
Good.
insurance providers may be helping with that.
We're doing that for our members.
CTSI might do the same thing for counties or whatnot.
So check with your carrier.
Any other questions about 1112? All right, well, let's go on to the next one. Next one is House Bill 221347. This was the negotiated bill. This was the bill that we sat down in that meeting with the WCEA and Pinnacle and CSIA, and we worked out these agreements. Now, you may say, well, Doc, why did you agree to these things? Again, in a perfect world, I wouldn't. But we, again, are in a defensive position. We try to mitigate these bills as best we can. We try to do research to see what the cost would be. And rest assured, we do all that we can to try and mitigate the effect of these bills. The first one, let me back up again. Because this is the negotiated bill, there's different parts to it. It doesn't just deal with one issue. The first issue is mileage reimbursement. The claimants bar came to us and said, listen, we hear stories of claimants who live out in the country, maybe on the western slope or eastern Colorado, and when they go to their authorized treating doctor, whether it be physical therapy or a physician visit or whatever, they have to travel a long way. And they're saying it's a financial burden on these claimants, and so they wanted mileage reimbursement to be prepaid if the trip to the authorized doctor was over 100 miles. That's what this is. If the trip is over 100 miles round trip for a claimant to go see an authorized doctor or for authorized treatment, not for an IME, that's ours. We already have to do the prepayment for IMEs. But this is just for authorized treatment. If it's over 100 miles, we have to do it. The request is made, we have 7 days to pay that request. So there has to be a request made. We have 7 days to do it. Now you may say, well, Doug, what if we pay that and they never go to the appointment? Well, that can happen. If they do, we get to credit that amount against any future mileage reimbursement. Not just a request for prepayment of mileage, but any mileage reimbursement that happens in the claim. So hopefully that will avoid those instances where we're paying out money and not getting it back. Any questions about the mileage? All right. Next is scheduled benefit changes. This is a little obscure, and I've tried to explain this to people that don't know workers' compensation. My law firm actually represents NCCI, which is the national pricing firm. And they recently, I had a conversation with them because they didn't understand what this bill was talking about. Let me see if I can explain. As you know, in Colorado, there are scheduled injuries, which are mainly to the extremities, or whole person injuries, which is to the trunk. Scheduled injuries have a different benefit formula than whole person injuries. Speaking generally, scheduled injuries, that formula results in less benefits than whole person injuries. Now, as you also know, a doctor can convert a scheduled impairment to a whole person impairment. We still should admit to the scheduled impairment, but the doctor can convert it. If you look at what a scheduled impairment would be using the scheduled formula compared to the converted whole person impairment and the whole person formula, the scheduled impairment 99% of the time is less than what the converted whole person benefit would be. There are those rare instances, though, when you figure out what these scheduled impairment benefits would be, and when you compare that to what the converted whole person benefits would be, the scheduled impairment benefits are actually more. What some people were doing is they were, in those rare instances, some people were not admitting to the higher scheduled impairment, but they were automatically converting. Now remember, I told you we typically never convert, but in these cases, they were converting to the whole person impairment and paying the lesser whole person benefits. And the claimant bar said, that's just crummy, you know? You get the benefit of scheduled on 99% of the cases, and then that 1% where the schedule actually pays more, people are converting and paying the less amount for the whole person. So what they said is, in those rare instances, when the scheduled rating would result in more benefits than the converted whole person rating, we are obligated to admit to the scheduled rating. We have to pay the scheduled benefit. You all are probably already doing that. Maybe not. You were perfectly within your rights to convert it and pay a lesser amount. But a lot of people just said, listen, this is what we do on 99% of the cases. We're going to be consistent. We're going to pay for the scheduled anyway and pay that higher amount. This statute now makes that mandatory. So, if an injury is a scheduled injury, and if the scheduled benefits is greater than the converted whole person impairment benefits, we must admit to the scheduled impairment. It's not going to, again, not a big, in the whole scheme of things, this is not going to be a big cost driver. Any questions about this scheduled impairment benefit part of this bill? All right, pretty easy. All right, next one, another easy one. Funeral benefits or burial expenses. Way back in the 1990s when Senate Bill 218 first came into play, the funeral expenses were put at $7,500. It hasn't changed for like 25 or plus years. So we raised it to $12,500. As you can imagine, you know, heaven forbid you know about this, but I'm sure most of us do, funerals are much more than $7,500. And so they raised it to $12,500. Even then, funerals, a lot of them, are more than $12,500. So, in order to avoid this problem from happening again in the future, the funeral expense benefit is now indexed to the state average weekly wage. So, you know how the state average weekly wage, the state comes out every July or mid-June and says, this is going to be the new max TTD rate, the new scheduled entry rate, all of that. This will now be changed in the same percentage that the state average weekly wage changes. That way, and typically the state average weekly wage increases every year, so this one assumes will increase every single year in that percentage. And hopefully we don't have this problem 20 years down the road where we have to deal with this again. All right, any questions about that, about the funeral or burial expense part of this bill? Okay. Next, reporting claims to the division. This caused a lot of consternation. For the last, I can't tell you how long, the claimants bar has been coming to us during these negotiation sessions to talk about legislation, and they have said, listen, we have claimants come to us where their medical expenses are getting paid, but they're not losing any time. So it's a medical only claim. As some of you may know, we don't have to report medical only claims to the division, meaning we don't have to take a position on them. We don't have to admit or deny them. We can pay medical expenses on a claim, and that payment of medical expenses is not an admission that we are admitting this is a compensable claim. So, again, these are all anecdotal stories. I don't know how often it happens, but the claimant bar says, oh, you know what, we get people that come in there and they have medical benefits paid for a year. And then all of a sudden, they have to have a surgery and they're going to be off work now. Well, when they're off work, now you have to report that claim to the division and take a position on it. And they claim that, oh, you know, we had cases where people come in all the time and say that they've been getting medical benefits for a year, they think it's been accepted, and then here comes the surgery request, and boom, the denial comes. Because the insurance company or self-insured employer doesn't want to pay for the surgery. Now, honestly, I don't think it happens very often, if ever. I can't remember anything in my own practice where I saw something like that happen. But these are the anecdotal stories that we get from the claimants bar. So they wanted to say, listen, we want every single claim reported, whether it's med only or a loss of indemnity benefits. We thought, oh my gosh, can you imagine every single claim reported? Now, cynically speaking, if every single claim were reported and you all had to start sending out forms, these official looking forms, first reports of injury, admissions, yada yada, what do you think a claimant who is getting all these forms in the mail is going to do? They're going to run out and get a lawyer. So even though the claimant's bar is trying to suggest that, oh, you know, this is for the benefit of the claimants because they really don't know what's going on, I think there might be a little more ulterior motive to try and generate more work for the claimant's bar. Because now these people are getting these forms, they don't know what this means, we better go out and get a lawyer. So they wanted every single claim reported. We said, wait a minute, if your objective is that, you know, you're afraid that a claim may last longer than 2 years, and then they have a report of surgery, and we're going to say the statute of limitation is run, why don't we just make it, you got to report a claim if it's still going on 2 years later. And they said, no, that's too far. So then they went to 30 days. We went to a year and a half. They went to 60 days. We went to 12 months. Long story short, we settled on 180 days, which is about 6 months. Now, you may say, well, that's going to cause a lot of additional work. I'm not going to say it's not going to cause any more work, but we actually looked into this issue with the help of Pinnacle Assurance, with the help of others, some large self-insured private and public employers. And we found that the effect of an 180-day deadline really doesn't cause that much more work. It really doesn't result in that much more of claims being reported. So what it is if you have a medical-only claim that is going on after 180 days, you have to report that claim to the division whether or not there's lost time. That 180 days is counted from the day the claim is reported, not the day of injury. Additionally, let's see. The claim needs to be, the medical treatment needs to be such that there has to be supervision from an authorized treating physician. So they've got to be under active medical treatment, under the supervision of an ATP. A prescription for a gym or home exercise or pool therapy or something like that, that does not qualify as active medical treatment. Additionally, active medical treatment ends if the claimant abandons the claim, abandons the medical care, or is discharged for noncompliance. So we try to put in there some things, and again, you know, you're trying to project into the future situations that we've never experienced before. So you're trying to think of these things. I can imagine there may be examples in the future that we did not think about. And you'll go, Doug, do we have to report this? Well, I don't know. We'll have to see what the situation is. But if the claim fits within this parameter, after 180 days, it has to be reported to the division. Yes?
On that webinar, we also heard that if claims closed, so they closed med only in 3 months, but a year later, they want to go back to the doctor, that's longer than 180 days, and they're saying we have to report it. Even though it really was only open a month, and now they're going back to the doctor a year
Right.
later. You have to
Now
report it.
keep in mind though, let's say they come back down a year later, you don't have an obligation to accept that reopening. You may say, hey, Mr. Claimant, you've got a new job now, and any exacerbation you have is a result of your new job. However, if you're going to deny that, what do you have to do with a denied claim? You have to report it to the division. So even if a year later down the road they want to go back for treatment, again, that's more than 180 days, you're going to have to report it to the division, either denying it or accepting it. Any other questions on this one? All right. We're into the last one. The last one is one that caused a lot of confusion, and frankly, is one that, we're going to kind of have to see how it plays out. This was not negotiated. To give you some history, this was from a representative. Let's see. I can't remember her name, but she was a freshman representative that kind of wanted to make her mark. She wanted to have a little notch in her belt saying that she had introduced a bill and passed it. A constituent in her district was a psychologist. And this psychologist complained to her saying, listen, in workers' comp, these mental health records are not being kept confidential. People that are unnecessarily are unnecessary to see the records are seeing the records. It's destroying confidentiality, and therefore that's a problem. So this representative came to us and said, listen, we want to do something to try and keep mental health records more confidential. All right. Well, again, the devil is in the details. How do we do that? So what this says is mental health records are to be kept more confidential now, more so than medical records. Well, what constitutes, first off, what is a mental health record? Well, the statute says it's a psychological or psychiatric test, including neuropsychological tests. It also includes other records prepared for or by or for mental health providers. It's IME records, audio recordings, reports that address psychological or psychiatric issues, dime reports, or substance use or abuse records. So you can see any record really that talks about mental health, whether it be depression or perhaps substance use, marijuana, anything like that would fall under this category. It then says that we can only give these mental health records to the insurer or self-insured employer as necessary to pay for the services or adjust the claim. All right? So, if you adjust your own claims in your public entity, or if you have a TPA do it, that adjuster is probably going to be okay to be able to see these things. I recently had a kind of a conversation with CCMSI where they said, well, wait a minute, what about accounts that have access to the claims file? You can log in and look at it, the claims file. What do we do with that? Well, unfortunately, unless it is somebody that is necessary to pay for the services, adjust the claim, or adjudicate the claim, that person really can't see the records. So you may have to have those records put into some separate confidential file with restricted access, so that if there's somebody that has access to those claim notes, they won't be able to see those records. Let's say that you have somebody, though, that has a mental health condition and they're trying to return to work. And they have restrictions and limitations. And so you've got to let the you've got to let the supervisor know or manager know, hey, Joe, he can't be working with people. Or he can only work 4 hours because it's too stressful for him, or whatever the case may be. What that says is we can provide those records as necessary to accomplish those restrictions. You can, let me back up, you can provide the information about the restrictions and limitations, but you can't provide the records to them. So you can't provide the record to the supervisor or the manager. We can also send the records to referring physicians. So if we have a doctor, for example, an IME or something like that, we can send those records to that doctor. We're allowed to do that. anyone who is not reasonably necessary to the medical evaluation, adjustment, or adjudication of the claim is prohibited unless we are ordered by the director. For example, when we file a final admission of liability, we have to attach the medical report that gives the impairment rating. What if that medical report talked about a mental impairment? Well, we're required to attach the report to the FA. We're required to send that FA out to everybody. So those would be instances where we are allowed to do that because it is ordered by the director. As I mentioned before, the employer, supervisor, manager who needs to know the work restrictions necessary to adjust or adjudicate a claim, but we can't disclose the actual records who is not to anyone who is not directly involved in those things. And then the statute also says if that mental health provider objects to the disclosure at any time, we can't disclose the records unless we get an order from the ALJ. So let's say you have a provider that says, no, I'm not going to send you these records because they're confidential. We're going to have to go to a judge to get an order. I know. I shake my head too. But that is now what the law is with regard to the mental health records. And this one actually went into effect when it was signed, and that was signed on June 8th. So these are things that we already should be doing in our claims. And so if you have a TPA, you might want to be just making sure, I'm sure they are doing it, but it's just something that we want to keep on our radar. So, the questions that I have, again, what about employers who have access to files of the insured TPA? What about MMI impairment rating reports or DI reports that have to be filed with the FAL? And then it applies to all claims filed on or after that June 8th date. That's what happened this last year. This next year, I can imagine, again, is going to be an active year. We probably, again, will be on the defense, trying to mitigate things. It's July. We typically start meeting with the WCEA and Pinnacle Assurance around October. The legislative session starts in January. We meet in October so that we can kind of get going. This last year we probably met 10 times. And hopefully we're able to be as successful this next year in mitigating the effect of these changes as we were this last year. But before I conclude, does anybody have any questions about anything about these bills specifically, or perhaps you have another question in general about workers' comp? Yes?
It's general, actually. Would you be open to sharing your presentation with us?
Sure.
That way we can just pass it along to people who need it.
Absolutely.
Thank you.
That's no problem. I don't know how you want me to do that, but I'm happy to do that.
We're making a video of it right now, so I think we're going to be able to post it on the website.
I can also send it to Jessica or whomever, just to say, here's my PowerPoint. And I don't know if you all have your separate website.
Yeah,
You can post it.
on the Capitol website.
I'll go ahead and do that then when I get back to the office. I'll send that to her. Any other questions about anything? Well, listen, thank you very much. I'm up 5 minutes over. I apologize. Thank you very much for letting me come by and talk with you today. Again, it's a pleasure for me to be here. If you have any questions or whatsoever, and as I mentioned to you before, we may already do work with you, but if you have any questions or whatnot, please feel free to give me a call. I'm happy to speak with anybody and answer any questions that you may have. And I look forward to the next time I can come back. Thank you very much.